green, reddish, brownish, small apples that I found in some backyard. We talked about it last summer. Might be tempting. Play it hard. Be right. So worth it.
It is. So everyone, disputes, they do not start in the courtroom. They do actually start a long time before that.
Oh, yes.
So it could be when you are starting a deal, for example, and you cannot agree, and then you're ending up in a dispute. But how do you actually avoid that before the trouble comes? Mm-hmm. And that's why we are here today, and we're going to go through this in Kat, our business lawyer.
It's so worth it.
Yes.
It's so worth it.
It is.
So we're going to be very like a checklist. We're going to keep it short and snappy for you to keep in mind how to act and how experienced lawyers act in negotiation processes to minimize that horrible situation,
yes,
the risk of ending up in a dispute.
So now you're going to have this knowledge when you are doing business to avoid disputes, because as Kat says, it takes a lot of energy and time.
Yeah. So we're going to be more and more concrete, so stay tuned.
Yes. Let's start with the first one. So before and during everything, prepare thoroughly. Yeah. How do we do?
Yeah, that might be self-evident, but make sure to do your homework. What is the baseline? What is market practice in your issue, whatever you're negotiating about? And also, what do you want? What's important to you and what is it the other party wants? Are you on equal footing or are you negotiating with a powerhouse? What's their drivers, their kickers, and what's yours? So define that before you enter into the negotiation. Don't wing it. That will help you out.
Yes, and also foster open communication.
Do. Because it might hit you like a curveball if you either the negotiations collapse,
yep,
or you end up in a lawsuit in the end, and you might have been able to pick that up early on if you had known the drivers of the other side. So foster good and clear communication without too many formalities. If you have lawyers involved, try to still have a good communication directly between the parties, so you don't leave it all up to the lawyers, because that when problems come, then you don't have any trust between you. So don't leave it all up to the lawyers.
Okay, and then next one is focus on interests and not on positions.
Harvard Negotiation School. That's a very good one. Because sometimes we get stuck in our positions and we forget about the bigger picture. What are we actually driving for? What do we want? So I might be I'm selling ice cream to you and you're buying ice cream for me. And my position is I will never deliver before 7 o'clock every morning. And your position is you will deliver before 7 o'clock every morning because that's when I do X, Y, Z. But if we start talking about interest instead, it might be that my interest is that there's very hard to get where there's so much traffic between 6 and 7. So if I have to deliver before 7, then I will have to pay an additional hour most likely for the chauffeur and for all of the traffic, and it will be so much more burdensome. And if you understood that, you might say, but I only need these parts before 7 every morning, and actually you can deliver them at 4 o'clock the day before, and the rest you can deliver them by noon or something. That's fine.
Make it so much easier.
Because then you knew the interest. What was the actual problem? Not the position. You're going to deliver at 7 o'clock. So find out why. The why, and you might be able to work around.
That's a really good one.
Yeah.
So avoid aggressive tactics.
Might be tempting to play it hard, to be right. But that comes with a hurt ego on the other side.
Yeah.
And if there's a hurt ego on the other side, when time comes for them to might file a lawsuit against you, because there is something went wrong, you might have effed up in some way, something is an issue, then they might pick up that phone and be forgiving and say, it's okay, I understand, you intended to, let's talk it out. They might be happy to pull the trigger and kind of nail you because you nailed them. So even if you win short term, you might lose long term. So avoid aggressive tactics. It will be harder to solve something going forward.
And the next one is document agreements as you go. We talk about this a lot, actually.
And many, many times I speak to my clients and they're frustrated. But he said,
Yeah.
we've talked about it. He said it. We talked about it last summer. He confirmed. We shook hands. And the other part is like, I don't understand. We never talked about this. I would never have promised that. No. Put it in writing and then wait with it.
Yeah.
So if we have a meeting and I feel like, now we agree, yes, I got my way. Then send a confirmatory email.
Yeah, that's good.
Thank you for the meeting, Ida. So glad that we agreed upon me delivering XYZ before 4 and the day before, and everything else I can deliver around noon. So I don't have to deliver anything before 7 o'clock the same day. Confirm.
Very easy.
Yeah.
So we're moving on. Use clear and precise language. I mean, it seems obvious,
It does.
but still people are having disputes.
And you have different kind of interest, right?
Yes.
I mean, imagine that you say, I want to buy red apples.
Yes.
And I say, of course, I'll sell you red apples. And you imagine these ripe, big, all like clear red apples, all kind of the same color. And I come with this like green, reddish, brownish, small apples that I found in some backyard somewhere. Like, sure.
Here's the red apples.
Yeah. And that's the same with every part of the agreement.
Yeah.
There's so much interpretation, so try to be clear about it. We talked about net working capital. What's included, what's not. I mean, it's super important and can have such an impact on your business. You might not be able to use those apples, but have to pay me if we don't define it clearly in the agreement, right?
Yes. So, I mean, even though it's obvious, we have to do it.
Yeah.
So, also, the next one is address potential issues.
Yeah.
When do you do that?
And this is a tricky one, because sometimes you just want to sign.
Yes.
Sometimes you take the risk. Yep.
To move
You're
on.
like, I don't want to bring it up again. We have a draft, let's go.
Yeah.
We'll deal with it. And sometimes that's better. But then know you're taking that risk.
Yeah.
And other than that, do address. Make sure you are in line, that you understand what's happening. Because otherwise it might come up and bite you later on.
Yeah. Come as a shock for one party.
Yeah.
And then educate the other party as needed. What do you mean by that?
Also, what we see when we deal with small and medium-sized businesses is that there's perhaps misunderstanding, genuinely so. You might talk about a ROFR, right to first refusal. What does that entail? What does that mean? And one of the parties says, yeah, sure, we'll have that. Lovely.
Yeah, sounds so good.
Yeah, and then they go sell their shares and they did not offer you any right to first refuse to buy them. Because they didn't really understand. And if you have that sense that the other party is being positive or wanting just not to look dumb, it could be, probe a bit. You don't have to ask like, oh, are you sure you know what you're talking about? But probe a bit. Okay, but if we have that ROFR, should we have a demand that is in writing? Do you think that the board of directors should send it out, or is it you? Try to ask questions and see if they really understand the concept you're talking about. And if not, in a not too bullish and not too kind of I'm a smart-ass way, explain how you think the process should look. So you also explain what the concept actually involves. So you're aligned.
Yeah, it's really important. And we do actually have an episode about ROFR.
True.
It's really good
Important.
one too. Yes. And then focus on fairness.
To keep it balanced. Because it could be tempting if you're the stronger party, or you're the more knowledgeable, or you're the one holding the pen, to make it very advantageous for yourself, or advantageous. And that might not even hold up in court.
No.
So let's say I include a liquidated damages clause where you pay me $1 million if you are late with, say, the paperwork 5 minutes that you owe me as a consultant. The court will most like say that that's not balanced. So I won't have to pay you that $1 million, even if it's a clear breach of contract because you did not show up. So be mindful to keep it balanced and fair. In particular, if you have consumers or employees, extra important.
Really good. And be ready for challenges.
Be ready for changes and challenges. Have an amendment clause. Be ready for have mediation in there, stuff like that, so you can kind of address issues, challenges that come along.
Good. And include dispute resolution mechanisms.
I was on to that already,
Yes.
right? Yeah. Make sure that you address how to attack an issue. And preferably, you will want steps before you go to court. Because you want to avoid going to court because it costs you money, it costs you a lot of time and headache. It's not fun. And also, there can be bad media for you. So perhaps you want a dispute resolution where you go to a mediator. You have an independent third party make the call. There are a lot of things you can do that cost less, go quicker, and that are less uncomfortable for you.
Great.
And have that before you're not in a disagreement.
Yes, really good. And the last one is address the way outs.
Yeah. So if you want to terminate, how should you terminate? Or do you want to force majeure if something happens so you cannot deliver? Make sure that is very clear cut, because that's also a situation where one of the parties might be super happy with the agreement and you might want to move on or make changes. So make sure it's clear how long will it last for and how will you terminate it, and make sure you know when to terminate it so you're not stuck in a prolongment of 10 years if you want out, for example.
Exactly.
Yeah. So be clear about that.
This is really good tips that you mentioned now, because I mean, making business, it has like the sense of everything is just straightforward, it's fast, and it's very intense. But I mean, when you talk about this, you get a lot from just discussing the things beforehand.
Be precise,
Yes.
or pay the price. Be precise or pay the price.
And that's from the business lawyer. So listen to that one. That's really good. Thank you so much.
Thank you.
And I think you who watch this have a lot more tools in your toolbox, and especially when you are avoiding disputes, because we do not want that. It takes time, it takes energy, and it can cost a lot of money.
Indeed.
And your reputation.
So, yeah. As a lawyer, I mean, of course, lawyers make money on disputes. Stay clear. Don't go there.
No, stay clear. Avoid it. Thank you so much. This is not legal advice. It's knowledge sharing. Remember that. But keep yourself educated. It's key for having good businesses. And this episode is also powered by LE Fitness. Like and subscribe to our channel, because these kinds of tips and tricks, I mean, you cannot find it everywhere, and it's at zero cost. We have a business lawyer here. So also take your time to ask questions. I mean, just drop them down below and we're happy to answer them.
Indeed.
Indeed. Until next time.
Hej då!
Hej då!